Today we go inside the Michigan DUI playbook, as we discuss the various case strategies, and which approach is best for different cases. A DUI defense will either be a trial of interpreting the facts in a different way than the prosecutor, or to outright confront those facts as being untrue. An interpretative defense is mostly agreeing with the prosecution's version with your own spin, but those facts don't meet the burden of proof, and you focus on that burden. This might be a good defense when you're working with a relatively low BAC number near the legal limit, but this would not work as well with a higher BAC number or other bad facts. If you're trying to defend a case with a BAC double the limit, timing, alcohol absorption and a different interpretation of the facts won't fly. You need to change the facts. You must put on a defense that shows lack of operation, or the double the limit chemical test is just wrong due to an error in the testing process, and it should be ignored. The most difficult task in defending a DUI charge is dealing with a BAC number over the legal limit. On top of that, there's testimony about how the method was reliable. There is a whole section of testimony about the reliability of the method, the training and certification of the person conducting the test, or testing the sample. You can establish the unreliability of the test results by comparing them with the behavioral observations of the arresting officers. Especially if there is a favorable video, this means the defendant avoiding sounding or appearing intoxicated in a video, no poor driving, and success on the field sobriety tests. The BAC number just doesn't match up, or you challenge the reliability of the test results by cross-examining the breath test operator or the MSP lab technician who tested the blood, and backs up the process. Regarding the procedures followed in test administration and the compliance or non-compliance with the applicable administrative rules, even if the BAC number is attacked effectively, a prosecutor will still argue some form of impairment as a backup plan to losing the BAC number. Impaired driving is still a DUI. It's so important to also focus on challenging indicators of impairment, which include the driving, officer observations, the PBT, field sobriety and defendant statements.